Case of the claimant is the story about that leads to the indefinite suspension without pay, and the content is contrary to the LACO code of conduct. He is claiming monies that he should have earned during that period of suspension. Case of the defendant is that they were entitled to still suspend the claimant. Defendant's written address, the defendant formulated 7 issues, whether the claimant has proved his case on preponderance of evidence before this court, whether the suspension of the claimant was regular in the eyes of the law, whether the claimant was subjected to any intimidation, torture, pain, or untold hardship of any kind, whether claimant is entitled to relief sought, whether the claimant was denied fair hearing in the adjudication of his supported suspension, whether the actions of the defendant is tantamount to unfair labor practice, whether the defendant is empowered to make policies for his operation, and whether the claimant is entitled to damages sought. Those are 8 questions. The defense counsel made submissions and answered all the questions in favor of the defense. Claimant final written address, the claimant formulated 4 issues, whether the queries dated 27th June 2018 and 28th June 2018 respectively has any legal basis, whether the suspension of the claimant was lawful, whether or not some of the documents tendered by the claimant is admissible in the interest of substantial justice in this case, in this suit, whether the defendant has established a case of defamation against the defendant to be entitled to the damages sought in his beliefs. The claimant counsel also made submissions in line with the questions and answered all the questions in favor of the claimant. The details are set out here. I'm reading them in summary. When I say he made submissions and answered them, it's just to avoid reading them again all over, but I've set them out here. Court's decision. I have read both pleadings, evidence, and documents sought to be relied upon in this case. Given the nature of the reliefs claimed and the questions put forward, especially by the claimant, it is my considered view that it is safe to have a general issue for determination as whether the claimant has proven his entitlement to any or all the reliefs claimed. In determining this issue, reliefs 1 to 5 shall be considered together and the remaining reliefs together. Before doing so, it shall be imperative to consider admissibility of documents first. Admissibility of exhibits EUS 5 to EUS 15. At the hearing of this case, defendant's counsel objected to 11 documents tendered by the claimant and reserved his reasons till final written address. These documents were marked as exhibit EUS 5 to EUS 15 and ruling reserved to judgment. In his final written address, learned defendant's counsel made no submissions against the admissibility of these documents, thus abandoning his objection. It was the claimant's counsel who raised and argued admissibility of some of the documents in his issue 3 by simply urging the court to invoke the provisions of section 12(2)(b) of the National Industrial Code Act 2006 and order 5 rule 2b of the instant rules of this court to admit these documents, that is exhibit EUS 5 to EUS 15. It was in reply on points of law that the defendant counsel walked up to urge the court to decline the invitation of the claimant, urging the court to depart from the strict provisions of the Evidence Act. It is the word may that was used in section 12(2)(b) of the National Industrial Code Act 2006. Counsel noted that the claimant did not comply with order 40 rule 28 of the National Industrial Code rules and section 91 of the Evidence Act 2011, that the tendering of documents without laying proper foundation in satisfaction of 40 rule 28 of the National Industrial Code rules and section 91 of the Evidence Act is not proper, and the defendant was not put on notice to produce the documents. carefully consider the claimant's amended statement of facts. The pleadings relating to these documents are to be found within paragraph 7, 18 to 39. Find therefore that these documents were all properly pleaded. By reason of Order 15, Rules 3 and 4 of the instant rules of this court, a defendant who intends to object to the admissibility of a document shall so indicate in his statement of defense, or he shall be deemed to admit them and shall not be allowed to raise any objection to the admissibility of those documents at trial. What then was the purpose of the defendants? What then was the response of the defendants to these documents as pleaded in the above paragraphs of the claimant's statement of facts? The defendant's response to the 42-paragraph statement of facts are in a 14-paragraph statement of defense. In none of the 14-paragraph statement of defense did the defendant join issues with the claimant on the facts relating to the pleaded documents, let alone indicate any opposition to any of the pleaded documents which were unloaded. By reason of Order 15, Rules 3 and 4 of the instant rules of this court, these documents are deemed admitted except the court otherwise directs. Now, the principle of law relating to documents is that documents admitted can only be expunged upon application by the opposing party or so motu by the court for reason that they were admitted in error. The defense counsel who reserved his reason for objection has abandoned his objection in his final written address. As far as admissibility of these documents on the objection of the defendant is concerned, there rests the matter. Now, the claimant counsel has brought up the admissibility of these documents in his final written address. Coupled with the power of this court to so much to raise the issue of whether these documents were properly admitted in the interest of justice, I shall now consider that issue. These documents are as follows: USE 5, letter of indefinite suspension. The date is there supplied. UES 6, reply to query, date supplied. UES 7, query dated 28 June 2018. UES 8, staff code of conduct. UES 9, reply to query. UES 10, claimant solicitor's letter. UES 11, performance sheet from January to June 2014. UES 12, payroll signature sheet, dated 1st December 2017. UES 13, retirement savings account statement from April to June 2018. UES 14, April payslip of the claimant. UES 15, June 2018 payslip. The documents marked UES 5 tender, UES 6 tender, UES 7 tender, UES 8 tender, UES 9 tender, UES 14 tender, and UES 15 tender. Though all photocopies and no foundation is laid, are documents that could be admitted in the interest of justice, as their existence or genuineness are not contested. Neither do they appear doubtful to the court. Admitting them will not in any wise prejudice the defendants. Accordingly, invoke the provisions of Section 12(2)(b) of the National Industrial Code Act and depart from the requirement of the Evidence Act and admit these documents, and they are to be marked as exhibits UES 5 to 9 and UES 14 and 15. I am fortified in my decision by the decision of the Court of Appeal Paramadi JCA in the Court of Appeal judgment Paramadi JCA I take that again. I am fortified in my decision by the decision of the Court of Appeal Paramadi JCA in Mr. Victor Adeboye versus United Bank for Africa unreported appeal number CA/IL/20/2021. A judgment delivered on 14th April 2022. As for the documents marked EUS 10 to EUS 13, they are a little different from the others. Exhibit EUS 10 is counsel's letter to the defendant. The pleading is that it was served on the defendant. In view of Exhibit EUS 4, a letter on behalf of the defendant by a counsel responding to EUS 10 tender. I find that Exhibit US 1010 that was actually served on the defendant, as the defendant could not have replied to a letter that it never received. Exhibit US 1010 that is accordingly admitted in evidence and marked as Exhibit US 10. Exhibit US 11 is pleaded and tendered as Abuja Region CSO performance sheet from January to June 2014. Its purpose, as stated by the claimant, is by virtue of my performance as revealed in the Abuja Region CSO performance from January to June 2014, I was not a lazy and indolent staff as alleged by the defendant in his letter dated 23 July 2018. In view of the claim and the issue before the court, whether or not the claimant is lazy will not help determine whether or not his suspension without pay was appropriately done in compliance with the defendant's code of conduct. The document is not helpful. The document does not have an author. It is not dated and it is not on the letterhead of the defendant. Its authenticity is doubtful to any reasonable mind, and for this, the document is rejected and is to be so marked. Exhibit EUS 12 suffers the same defects and thus the same fate. It is rejected and is to be so marked. Exhibit EUS 13 is a retirement savings account statement for April to June 2018, but it is not signed by the bank and no certificate of authentication. Its source is apparently doubtful to the court. In the absence of the bank stamp or any form of authentication, the document is rejected and is to be so marked. Merit of the case. The issue for determination is whether the claimant has proven his entitlement to any or all of the reliefs claimed. In determining this issue, prayers 1 to 5 shall be considered together. These prayers are as follows. A declaration that the purported suspension of the claimant without pay from the employment of the defendant by letter dated 29 June 2018 is unlawful, wrongful, null and void, and a violation of Black Code of Conduct for staff of Black Microfinance Bank Limited. A declaration that the claimant is still in the employment of the defendant and therefore entitled to the rights, benefits, and privileges, including salaries attached to my employment status from July 2018 up to date of judgment. A declaration that the claimant was unjustly accused and unjustly offended by the defendant without any legal justification. Declaration that the defendant's allegation of assault is a fabrication of falsehood and same is injurious to the claimant's reputation. Declaration that the actions of the defendant is malicious and punitive and same is tantamount to unfair labor practices. For a start, it is not within the jurisdiction of this court to determine whether the allegation of assault made against the claimant was a fabrication of falsehood, unjust, or malicious, but whether the indefinite suspension without pay was a violation of the NACO Code of Conduct for staff of Black Microfinance Bank Limited. How was the indefinite suspension without pay a violation of the Defendant Code of Conduct? From the content of Exhibit UES 5, the letter of indefinite suspension without pay, the grounds for the suspension is gross misconduct, insubordination, and assault. It must be made clear that at the onset that the duty of this court is to determine if the indefinite suspension for these allegations was in line with the NACO Code of Conduct for staff of NACO Microfinance Bank Limited. Exhibit EUS 8, the contention, that is the Code of Conduct is Exhibit EUS 8. The contention of the claimant counsel is that there is no provision in the Code of Conduct for indefinite suspension without pay. It is also his contention that Article 5, Table 2 of the Code of Conduct were not followed. The response of the defense counsel to this is that the claimant failed to take cognizance of the testimony of the defendant's witness that the Code of Conduct was not the current document regulating the defendant, and the claimant failed to serve a notice to produce on the defendant to produce the original document. This is a strange or rather misinformed position. The claimant pleaded the code of conduct and front-loaded same. If the defendant had any problem with the document as one that is no longer extant, it was the duty of the defendant to say so in his statement of defense and to front-load the current code of conduct and tender same in evidence, not for his witness to simply say in cross-examination that it has been changed. There is no other code of conduct before the court to determine which one is applicable and which one is not. Exhibit EUS 8 is the only code of conduct before the court, and the court has a duty to rely on same. Now to the code of conduct, Exhibit EUS 8. Under Article 3, titled Disciplinary Actions, it provides as follows. For the purpose of enforcement of these rules, the following are disciplinary actions: warning, reprimand, suspension, demotion, disengagement, and 6, dismissal. Breaches and sanctions are summarized under Article 5, Table 2. With respect to gross misconduct and assault for which the claimant was indefinitely suspended without pay, the table provides in columns 22 and 46 as follows. Column 22, insubordination and misconduct. The punishment is suspension for 1 month at the first instance and disengagement thereafter. Column 46, assault of fellow staff. The punishment is suspension for 1 month without pay, then 2, disengagement of employee and handover to law enforcement agents. What is clear from the above provisions of the Code of Conduct is that there is no provision for indefinite suspension without pay. It is suspension for 1 month without pay. Punishment imposed is beyond what is in the contract. This is not allowed as an employer only has discretion to impose a lesser punishment on an employee, but not a higher punishment. See Idigbe versus FCDA 2003 10 Nigeria Law Report, 829, page 486, where the court held an employer has discretion to give a lesser punishment to an employee, but it has no discretion to give a higher punishment than that prescribed. See also, okay. There is also no evidence that the claimant was investigated and his guilt established by the company, let alone handing him over to the law enforcement agencies. I accordingly find and hold that the indefinite suspension without pay meted on the claimant by the defendant was contrary to the defendant's code of conduct and same amounts to unfair labor practice. Now, the claimant was suspended on 29 June 2018, and this suit was filed on 11th April 2019 after a period of 10 months, and up to date, a period of over 4 years, the defendant is still quiet. During the period of suspension, the employment contract still subsists. See Mobile Producing Nigeria Limited and Tom Udo, citations applied. Longe versus First Bank of Nigeria PLC, citations applied. Mobile Producing Nigeria Limited versus FM, citations applied. And Aloysius Diamond Bank PLC 2015-58, Nigeria Labor Law Report, part 199, page 92, at page 32, at pages 39 to 40, where this court sitting at Port Harcourt Division held Pakola Olalere J. held as follows. However, the law is right that suspension is not termination nor dismissal. Consequently, within the period of the suspension, with or without pay, indefinite or for a specific period, the employee so suspended is still in the employment. His employment was merely put on hold to enable his employer to properly investigate the allegation against him, and so the employee will be entitled to salaries and allowances for the period of the suspension. quotation close. Also follows that since the Code of Conduct prescribes indefinite suspension without pay for only 1 month, indefinite suspension of the claimant without pay is wrongful. Without pay is wrongful, and the claimant is still entitled to his salaries and emoluments from August 2018 after the end of the first month of suspension, 29 July 2018 till date, a period of 50 months and 17 days, and I saw order. Prayer 6 to 15 are as follows. An order compelling the defendant to remit 2% per month of each monthly unremitted pension fund contributions as default penalty from July 2018 up to date of judgment into the claimant's pension fund account with Crusader Sterling pensions remitted within 7 days after judgment. An order of court compelling the defendant to remit the claimants. Well, they are set out here. We are going to treat them one by one. Having found and held that the claimant is still entitled to his salaries and emoluments from August 2018 after the end of the first month of suspension, 29 July till 2018, till date, a period of 50 months and 17 days, it follows without much ado that prayers 7 and 9 also succeed, but with effect from August 2018 and are accordingly so ordered. The claim for 2% default penalty has not been proven and is dismissed. With respect to relief 9, from 2018 to September 2022, out of the 50 months, there are 4 December months at 126,647.89 times 4. It will give us 506,591.56 naira. Then we are left with 46 months at 81,940.31, which gives us 3,769,254. With respect to annual leave, 2018 to 2022 will be 5 annual leaves at 36,327.16 times 5, which gives us 181,635.8. Now the total sum of 506,591 plus 3.7 million plus 181,000 gives us 4,457,481.62 kobo. The defendant is to pay the claimant his emoluments from August 2018 to September 2022 at the sum of 4,457,481 naira. The claimant is also entitled to remittance of his pension fund contribution for 50 months, beginning from August 2018 to September 2022, at the sum of 12,864 naira 74 kobo times 50, which will be 643,237 naira, and I so order. With respect to relief 7, the claimant has not disclosed the ground for asking the defendant to furnish the claimant with the evidence of payment or tax receipt of his personal income tax from May 2013 up to the date of judgment. This head of claim fails and is dismissed. With respect to relief X, apart from saying he is so entitled, there is no proof of his claim, of this claim, it fails. The claims for punitive and general damages reliefs 11 and 12 are refused in view of the award of claimants' full emoluments as special damages from August 2018 to September 2022, as it will amount to double compensation. Relief 12, relief 13 is granted at the discretion of the court at 10% interest per annum. Relief 14 is granted in the sum of 400,000 naira only as cost of action. Summary. In summary, the court finds and holds as follows. It is not within the jurisdiction of this court to determine whether the allegation of assault made against the claimant was a fabrication of falsehood, unjust or malicious, but whether the indefinite suspension without pay was a violation of the LACO Code of Conduct for staff of LACO Microfinance Bank Limited. 2, it was the duty of the defendant to plead and to front-load the current code of conduct and tender same in evidence, not for his witness to simply say in cross-examination or even examination in chief that it has been changed. 3, the defendant has discretion to give a lesser punishment to an employee, but it has no discretion to give a higher punishment than that prescribed, and the punishment of indefinite suspension without pay is higher than what is prescribed by the defendant's code of conduct. The indefinite suspension without pay meted on the claimant by the defendant was contrary to the defendant's code of conduct and same amounts to unfair labor practice. Since the code of conduct prescribed indefinite suspension without pay for only 1 month, the indefinite suspension of the claimant without pay is wrongful. Since the code of conduct prescribed suspension without pay for only 1 month, the indefinite suspension of the claimant without pay is wrongful, and the claimant is still entitled to his salaries and emoluments from August 2018 after the end of the first month of suspension, which is 29 July 2018, till date, a period of 50 months and 17 days. The claimant is entitled to the sum of 3,769,254 naira 26 kobo, being 46 months salaries and entitlements from August 2018 to September 2022, and the sum of 506,591 naira being December payments from 2018 to 2021. The claimant is entitled to the sum of 181 naira 181,635 naira 8 kobo being his annual leave from 2018 to 2022. The claimant is also entitled to the remittance of his pension fund contribution for 50 months, beginning from August 2018 to September 2022 at the sum of 643,237 naira. Court order. For all the above and for avoidance of doubt, the court hereby declares and orders as follows. 1, a declaration that the indefinite suspension of the claimant without pay from the employment of the defendant by letter dated 29 June 2018 is in violation of the LACO Code of Conduct for staff of LACO Microfinance Bank Limited and wrongful. Declaration that the claimant is still in the employment of the defendant and therefore entitled to all the rights, benefits, and privileges, including salaries attached to his employment status from August 2018 up to date of judgment today, 17 October 2022. The indefinite suspension of the claimant without pay is hereby lifted from today, 17 October 2022. A declaration that the actions of the defendant is tantamount to unfair labor/employment practices. An order of court compelling the defendant to remit the claimant's monthly pension fund contribution of 12,864 naira 74 kobo from August 2018 up to date of judgment, amounting to 643,237 naira into his pension fund account with Crusader Sterling Pension Limited within 7 days after judgment. I think it's 21 days. Within 21 days after judgment. An order of court compelling the defendant to pay the claimant the sum of 4,457,481 for being all his salaries, rights, benefits, and privileges attached to his employment status from August 2018 up to September 2022 as stated below. A is the sum of 81,940.31 kobo being monthly salary for the deduction, excluding the month of December, amounting to 3,709,000 naira, 3,709,254 naira 26 kobo. B, the sum of 126,647 naira 89 kobo being net pay, 13th month salary for the months of December 2018, 2019, 2020, and 2021, amounting to 506,591 naira 56 kobo. C, the sum of 36,327 naira 16 kobo being annual leave allowance from 2018 to 2022, amounting to 181,635 naira 8 kobo. 7, the sum of 400,000 naira is hereby awarded as cost of this action. 8, all the above sums are to be paid within 21 days of this judgment, or the sums shall attract 10% interest per annum. This is the judgment of the court, and it is entered accordingly.
As the court pleases, we are most grateful, my Lord, for the judgment. We are very grateful, my Lord. And the Lord continue to increase my Lord in wisdom, in Jesus' name. Thank you very much, my Lord.
You are welcome. Yes, Chief. Chief Inokoju. Chief Inokoju.
I think his mic is muted.
Okay. The judgment is ready. You can get your copies tomorrow.
As the court pleases. Thank you very much, my Lord.
Thank you. I think that is all for the Zoom, and we shall all leave.
All right.
Now the court places. I would do. You want to say to me? I don't know.